Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we are here to provide clear and practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. And while this isn't legal advice that I'm giving you, it is meant to empower you with the knowledge you need to move forward and to move forward with confidence. Today, we're examining a topic that's frequently overlooked until it becomes a flashpoint in divorce proceedings: the ownership, valuation, and division of yachts and aircrafts in Ontario. For many affluent couples, these assets represent more than transportation or recreation. They're often significant investments, lifestyle markers, and sometimes even business tools. A yacht valued at hundreds of thousands of dollars or a private aircraft worth millions can become one of the most contentious issues in property division. The law treats these assets with particular complexity. Unlike a bank account that can be easily divided, yachts and aircrafts involve federal registration requirements, cross-border enforcement challenges, and valuation disputes that can significantly impact your equalization payment. We'll examine three critical areas. First, how Ontario courts classify and value these assets. Second, the strategic challenges involving disclosure and preservation. And third, the practical enforcement issues you need to anticipate, especially when these assets are registered or located outside of Canada. So let's begin. Under Ontario's Family Law Act, yachts and aircrafts are classified as personal property and included in your net family property calculations, unless specific exclusions apply. And we're going to talk about that. Here's what you need to understand. If the asset was acquired during the marriage using marital funds, it's presumptively subject to equal division through equalization. However, the analysis becomes more nuanced when inheritance, gifts, or corporate ownership comes into play. In the 1979 Court of Appeal decision, that is Bregman v. Bregman, a sailboat owned by a family corporation and used almost exclusively by the husband was found not to be a family asset. The key factor: the wife and children didn't ordinarily use or enjoy it. This case illustrates an important principle. Corporate structuring and actual usage patterns do in fact matter, and they matter a lot. Contrast this with Wells v. Wells from 1983, where a sailboat valued at $48,000 was treated as a family asset because it was used by the family, even though maintained largely by the husband's business. The court ordered it sold with proceeds divided equally. The takeaway here: don't assume that corporate ownership automatically shields these assets from division. Courts will look through corporate structures to examine who actually uses and benefits from the asset. Exclusion from equalization can apply if you can trace the asset's acquisition to excluded property, typically inheritance or gifts from third parties. But here's the critical requirement: you must establish a clear paper trail. The 1996 decision in Cassidy v. Cassidy dealt with a boat that was purchased partially with inherited funds. The court applied the exclusion only to the portion directly traceable to the inheritance. If you purchase a yacht or aircraft using inherited money, meticulous documentation is essential. Bank statements, trust distributions, and contemporaneous records connecting the inheritance to the purchase will be critical if the matter does in fact proceed to trial. Now let's talk valuation, because when you're dealing with yachts and aircrafts, this is where things can get very, very heated. These aren't assets you can Google and call it a day. You value them, and how you value them can swing the numbers by six figures and sometimes more. A great example is the Kles v. Herc case from 2018. The couple is fighting over the value of two luxury boats. One spouse came in with a depreciation valuation that was backed by expert evidence. The other, well, they pointed to later sale prices and some unsupported estimates. The judge wasn't having it. The court preferred the structured, expert-driven depreciation method and set the values of those at $125,000 and $100,000. And here's the key takeaway there. The judge made it crystal clear. You value these assets as of the date of separation, not based on whatever fire sale price you get years down the line. So why does that matter? Because luxury assets like yachts and aircrafts drop in value very fast. Spend $200,000 today and just a few years later, it could be worth half of that. And if you're the one holding the asset, be ready to back up your valuation with real evidence, because courts will always see through creative pricing. In high net worth divorces, disclosure issues are common. Yachts or aircrafts can be hidden, undervalued, or shifted offshore. Ontario's Family Law Act requires full disclosure of assets at marriage, separation, and filing, and courts take failure to file seriously. In Pratt v. Korsalunik, the party didn't disclose foreign assets. The court relied on the other spouse's evidence and drew adverse inference, leading to unfavorable valuations and costs. To prevent assets from disappearing, preservation orders are crucial as well. Under Section 12 of the Family Law Act, courts can freeze property to stop depletion. With movable luxury assets, yachts in the Caribbean or aircrafts registered abroad, act early. They can literally sail or fly away. Interim preservation orders may be essential from day one. Perhaps the most vexing issue arises when these assets are registered or located outside of the province of Ontario. Yachts and aircrafts are subject to federal registration under the Canadian Shipping Act and the Aeronautics Act, respectively. But many high net worth families register vessels in foreign jurisdiction for tax, operational, or regulatory reasons as well. One case that really highlights the complexities of high-value international assets in divorce is the case of Stefanu. The spouses jointly owned a yacht registered in Ontario, but kept and used it in Greece. That created not only a valuation issue, but also a major jurisdictional battle. That is, which country's law should apply. At first, the Ontario court put the case on hold, saying Greece was the proper forum. But then new evidence showed the spouses also had major North American bank accounts. The Ontario Court of Appeal stepped back in and kept the case here. Ultimately, however, when the property division was decided, the court ruled that Greek law applied because Greece was the couple's last habitual residence. The result, the yacht, worth about $100,000, couldn't be sold because it was jointly owned overseas. Instead, the court ordered one spouse to buy out the other at a share of $50,000 payout to resolve the issue. The lessons: foreign registration creates jurisdictional complications. Even if you obtain an Ontario order, enforcement may require cooperation with foreign authorities or courts. Asset location does in fact matter, and litigation over these issues can be protracted and very, very expensive. Well, that's it for this episode in Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own journey through your divorce or separation. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions at all, the Riley firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.